I was
Yeah, it's right. Alright, I'll be right back.
Yeah, I'll try to keep eye contact with you. So
okay, go ahead.
but don't. No problem.
Okay. Oh. Okay. Okay. Thank you.
Learn my lesson. No more bills on me.
Okay. Yeah. Maybe we need to talk about that. Anybody want to come? Anybody want to come? Cornelius said yes for it.
Don't say
House Judiciary Committee call to order. I would now ask the Secretary to take the roll.
Representative Cox.
Here.
Representative Elmer. Representative Colonna.
Here.
Representative Cornejo. Representative Hard.
Here.
Representative Higdon.
Here.
Representative Kelly.
Here.
Representative Lira. Representative Marshall.
Here.
Representative McManus.
Here.
Representative Mitten.
Here.
Representative Richardson.
A quorum having been established, we'll continue on. This is the hearing on the joint hearing on the House Resolutions 380, 476, and 923. We're going to take all of the proponents' testimony first, then have a public hearing in regard to the people who oppose it for information. I think, terminated Representative Moon's presentation by a little bit. He wanted to at least summarize her. Representative Moon, proceed.
Thank you, Mr. Chairman and committee. I do want to take a few moments just to go over some of the points that I made in my presentation last week. I mentioned, first of all, that a year ago, last week in fact, that I was elected in the special election. I also believe that when I swore an oath to support the Missouri Constitution and the United States Constitution, that I am obligated to consider what is done and what is not done, in fact, with regard to different branches of government and even within our own house and in my actions as well. With regard to elections, a writ of election was issued in my case, the race that I eventually won, vacated on December 21st, 2012, and the governor made an appointment, which resulted in the vacancy. That writ was actually issued on January 17 of 2013 for an election date of April 2nd. That was the next regularly scheduled election. And I mentioned that that time span appears to be within the bounds of the Constitution and the statutes, which reads in the statute 21.110, the governor, when he receives any resignation or notice of vacancy, or if he's satisfied with the death of any member of the House during the recess, he shall without delay issue a writ of election to supply the vacancy. And then we moved on to Jason Smith, former House Speaker Pro Tem, who vacated his house on about June 5th when he swore an oath to uphold the U.S. Constitution and was seated in the U.S. House of Representatives. Last week, it was about 10 and a half months since that seat's been vacated. It's a little bit more, of course, today. And the seat's still vacant. Additionally, 2 seats were vacated, House seats were vacated in January, or December, I should say, of 2013. And also a Senate seat was vacated, one due to a resignation and the others due to appointments made by the governor himself. So when we take a look at the statute, when he receives any resignation or notice of vacancy, it would lead one to believe that if he made an appointment, and he would have been aware of the vacancy. And it is my assumption, as I read the Constitution and the statutes, that he is obligated to issue a writ of election to fill those seats. Now, as you may know, there were lawsuits filed against the governor to force his hand, and those who were returned, petition denied. When I looked at that, I thought it was kind of funny. When I was a kid, one or both my parents would ask me to do something or not. And if I wanted to do something, they would give permission or not. And on an occasion when they would tell me no, and I might reply why, they would say, because I said so. Now that's appropriate, I think, and within the confines of a parent's parental authority that they can say without giving any reason for the denial of my request. However, I believe it is prudent for our courts to be able to give a reason why. Yet when they issue these denials, simply petition denied without any explanation, I believe that they should be held accountable too for why. Why would they deny a petition from the people asking for representation? That question is still out there. So when the August election finally was called by our governor for August 5th, the 120th seat will have been vacated 14 months. The 67th and 151st seats will have been vacated 7 months. And the 22nd would have been also. However, I think there's a glaring oversight that there has been no call for the 22nd, the Senate seat district. In addition, there's the second seat that has been vacated due to a governor appointment. And while there's no timeline by the Constitution, it's required, the statute I referred to earlier does require the governor to act with haste. I want to reiterate too that when you pass up one election, that could be surmised as a delay. An opportunity when it's missed is a delay. And I mentioned briefly that I missed an opportunity to file my Missouri Ethics Commission quarterly report on time. And as you know, that when whatever you do, whether it's a commission or no mission, there is a consequence. And the consequence for me was a fine, which I had paid. I believe the governor should be held to the same standard as we all are. If there's a question regarding a commission or no mission, he should be given the opportunity to answer the question as to why he has taken the course that he's taken. I believe that you would all agree that the some 285,000 Missouri citizens who are currently unrepresented across the state of Missouri deserve to be represented. I mentioned also in Section 1 of Article 7, the reasons for impeachment are listed. In this case, Willful neglect, I believe, is the fitting category that this would be under. According to the Missouri Constitution in Article 7, the responsibility of impeachment lies solely with the House of Representatives. When you consider our responsibility, I believe it's serious enough that for these citizens who are currently unrepresented, we need to, on their behalf, ask the question, why? According to Black's Law, willful neglect is the intentional failure to perform duties because of negligence. And further, intentional is defined as a thing done with reason and purpose. Black's Law goes on to say that negligence is defined as the omission to do something which is a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs would do. And again, I believe this is the heart of the issue. I don't pretend to have all the information, and I don't think within a week either of us have gathered the information that would satisfy us as to why there's been a delay. The governor hasn't divulged it, nor has his staff, of course, the Solicitor General. And again, for this reason, I believe we must ask for his answer for the sake of those more than 285,000 citizens who deserve to know why they're without representation in the General Assembly. You and I took the same oath, which includes, I do solemnly swear or affirm that I will support the Constitution of the United States and the state of Missouri. And a synonym of the word support is defend. Almost as if we're in our battle armor and we're ready to fight against anyone who would dare to infringe upon that, whether it's attack or harm or danger. I've been elected by the citizens of Lawrence County, as you have by your representative districts, and entrusted by them to defend the laws of our state. I know you realize that only the House of Representatives has the authority to file impeachment. And impeachment is not a guilty verdict. It's just merely the leveling of a charge. If we neglect to do our duty, then that prevents someone else from an action. And we have an obligation to protect the integrity of the Constitution. It's not an easy thing to do. I understand that. As I looked through some of the information to support why I believe it's important that we move this resolution to the full House for consideration, I found some interesting things. Back in 2011, an election was called for the 15th district. It was to be scheduled for November 8th. Governor Jay Nixon, current governor, decided on that date of a special election for filling the vacated seat by former Representative Sally Faith. It was stated by Scott Holst, Nixon's press secretary, that the governor set a date for 4 special elections so House members could have those seats filled before the start of the General Assembly in January. Nixon, according to his press secretary, believes the representation of those districts should be in place by then. What a novel idea. Now, had he only used the same logic as he used in filling this seat with those that are currently vacant, I perhaps wouldn't be sitting in front of you today. In addition, we looked at some past histories on governors, Governor Wilson, Holden, Blunt, and Nixon, for example, and determined what time factors or what time delays were present and evident between the notice of a vacancy, the call for the writ, and the ultimate filling of that seat by election. The averages for our governor were pretty good until currently. And with comparisons from Governor Wilson to Holden to Blunt to Nixon, Governor Wilson in 2000 had an average time of 72 days. Governor Holden, 124. Governor Blunt, 140. And I should pause to say, too, that when a 2006 election was called by Governor Blunt, this is a quote from an article titled "Blunt Sets Special Legislative Elections." The quote here is, "Democrats accuse Blunt of politics in setting the Senate election 2 months after the special House election." And now I want to point out that Governor Nixon's average is 169, considerably higher than the others. There's a principle that we use in our government, consent of the governed. And I believe that we need to remember that when people come together to determine laws, and that's what we are doing, it should be for the good of the whole. In order for this to work, the people must have a voice. In our form of government, a republic, the people must have representation. In Article 1, Section 1 of the Constitution of Missouri, it states that all political power is vested in and derived from the people, that all government of right originates from the people, is founded upon their will only, and is instituted solely for the good of the whole. If in a republic, the people have the final say, they do have the final say. We live under laws to which we have consented, that is, if, and only if, we've had a voice in the matter. If the people of the 67th, the 120th, the 151st, or the 22nd Senate District, and now the 2nd, do not agree with the law that's been passed, who do they cry out to? Who do they unelect in the next election? You? Would it be me? Absolutely not. They have no recourse. Wait, yes, they do have a recourse. And we are their recourse. To hold accountable the one responsible for their lack of representation. It matters not whether we like the individual, their party affiliation, or whether or not we agree with current law. What matters most is that we uphold the law. And now the decision is your hands. I implore you, I beg you, vote to allow the full House to hear the debate, and let them decide for the people of this state.
Thank you, Representative. I want to remind other witnesses that we do have a court reporter here present, and although Representative Moon was introduced, if you're not introduced, we need maybe help with the court reporter with the spelling and so forth. We thank you, Representative Moon. I've got just a few questions. I think the first one you have responded to already, because I'd asked the previous representative the specific provisions of the Constitution you say here today is willful neglect is what you think is specific.
Yes, sir.
Why? In regard to these three districts, one of which was a result. One was a result of a individual seeking a congressional race. That's the one, the longest vacancy. One of them was a resignation because I think the person had some charges. I think.
Yes, sir.
Or at least was accused of something wrong. And then the other one was a direct relationship of some action by the governor, and you pointed that out.
That's correct.
Is that the 67th? Is that the right district?
That would be the 151st.
That's the 151st. Okay.
Yes, sir.
And in regard to that, as I understand, having read press accounts, that one of the members of the House of Representatives, a member of the majority party, was appointed by the governor to a state board. Is that right?
And within these three?
The 151st district.
That is
That's
correct.
the history. Okay.
Yes, sir.
Just as an aside, I don't think it really makes any difference. The Senate did not confirm that individual, as I understand.
That's correct.
Okay. In regard to those particular facts, do you think that it is important that knowing the balance of the relative power between the governor's party and the not governor's party, and knowing, for example, a vote count to override a veto or the extraordinary vote numbers necessary to do that, as I understand is 109, do you think if the body tried this case, or if we, in considering whether to move this forward or not, do you think that the consideration, if the governor took an act to have a political impact on the legislature by not the act being not filling the vacancy once the appointment was made, do you think that is something worthy of consideration by the body? Does that aggravate the circumstances, or is that unrelated to the circumstances?
Mr. Chairman, I have been asked by several, even among my own party, about whether or not this is political. My first response is no. I don't know the governor personally. I would hope that I would have the backbone to take the same action if the sitting governor were a member of my own party. I would hope that would be true. As I began to consider our history as a nation, particularly, I found that I believe it was Justice Story, one Supreme Court justices long ago, who stated that impeachments are only political because they're not criminal. And so I have to retract my earlier statements in defense and say, yes, it is political. Now, whether or not we should do it for the sole purpose of regaining a majority in the House, I would say no. My primary intent goes back to my personal experience, in that I filled a vacant seat, and the vacancy was created for the same purpose as in the 151st.
It was also an appointment.
It was an appointment to the same board. Right. This particular representative, though, did not resign before the appointment was confirmed. So, yeah, anyway, that's beside the point. But in any case, some will say it's totally political.
I guess my question.
I say it's a duty that we have.
Right, I understand. I guess what my question is maybe just the opposite of that. And I'm not saying what should motivate us to do something, because I absolutely agree that we should not take the proposed action based upon some possible political gain, even though the process is by definition, a political process. You know, something that we decide. We should do it for the right reasons, not the wrong reasons. But my question is, if the governor made his decision not to fill this vacancy because of some narrow political advantage he might gain by keeping the numbers of majority down, is that a factor that we should consider whether or not it's our appropriate duty to vote this out of?
It is an extenuating circumstance, certainly. Whether or not that would be at the top of your list on the reason for considering it, I would personally say no, because I don't want to send a message to the House or the Senate or the public, for that matter, that says we only do things that will positively affect one party or the other. If we do that, we're no better than anyone else, and that should be set aside if at all possible. Probably not going to be totally, but that would not be my primary purpose for sending it to the full House.
Okay. Thank you. I will ask you the same question as Richard Marshall as far as alternatives. We talked about that. I mean, is there an alternative if we believe as a body that this was a wrongful act, resulted in or constituted willful neglect of his duties by not calling the election more promptly, are there any alternatives that we can take? Anything at all? I mean, I guess we could complain.
Certainly.
Complain. Yeah, which I think there's been some complaint. Anything else?
Reading the Constitution and the statute, I don't see another method that is available to us.
Any other questions of the bill's sponsor?
Just to inquire briefly, please. Thanks. Good afternoon, Representative.
Good afternoon.
Just a couple questions. So I know we kind of talked a little bit about how the political side of this is unavoidable. There's certainly that element, it sounds like, from your perspective. But I'd like to kind of put that aside and just talk legalities of it and what the statute says. And I think your articles are actually probably less complicated in a lot of ways than some of the other ones, because it really just comes down to a pretty simple thing, which is time. I mean, it's a matter of math, really, at a certain point, as to whether there's been delay in bringing an election. One thing that makes it difficult for me is I'm looking at the statute and I'm looking for that time that's required. And I think I heard you say that, you know, what is the statute say as far as time? And it says no delay, but it doesn't set forth an express time provision, does it?
No, you're correct. I would think, though, that if you consider what our own governor has stated, in setting the November 8th of 2011 election, that he considered that as well, because he did take measures to set an election that would have the potential to have representatives in place before the next General Assembly was seated. And so I agree, the Constitution or the statute does not specify time. However, I think a reasonable man would say, I think people need to be represented, and the next possible election, which would have been, in one case, the August election a year ago,
Right.
then we had even a September possibility, a November, could have had one in February, could have had one in April. So there's 4 or 5 different opportunities that were missed.
And you're hitting on, I think, exactly the point that we need to hone in on when we're looking at your articles, which is the reasonableness test. Because in the absence, I mean, legal interpretation is always, if there isn't an express time period put in statute, then the question is one of legal interpretation of what is a reasonable time. And that can depend upon facts and circumstances of the case. It could depend upon case precedents of past actions, and but ultimately it's an interpretation of the statute, as to what is reasonable in that situation. And I think you and I probably agree that reasonableness can change on the circumstances of an individual case, could it not? I mean, in certain situations, it may be reasonable to call it immediately because there's an upcoming election already scheduled. It won't cost the state any more money, and we'll just call it right away. In other situations, it may be reasonable to wait till the next general election because it will save the state money. And I think that's what we see governors do over time. I mean, whether we want them to have that discretion or not, it's been there over time because, as you said, even blunt, there's been some delay. I mean, certainly some delay. The question then becomes, what's an impeachable delay, right? I mean, that's the question I think we're presented with. And is there such thing as an impeachable delay? Can a delay be impeachable because there's such discretion in setting it under statute? I mean, have you thought about, I don't want to give you any ideas, but putting a hard time limit in statute? Because wouldn't that solve the problem?
Certainly have. I think when you do that, though, you're talking about other circumstances that may be affected, perhaps adversely as well.
Right.
In fact, when I was taking a look, I contacted some county officials and asked them about it, and they said, well, we have asked for a delay before election not be scheduled so that we can have opportunity to select a candidate. I think that's reasonable. Their request was 2 weeks. And so whether that's enough time or not for all counties across the state, I don't know.
So there's a practical problem with putting in a hard bright line rule.
I think so.
Because there's just an issue of, can we foresee the circumstances where that might not be reasonable or even practical? It may not be possible given the circumstances of the situation. And so I think that's probably why we don't have that bright line rule. I guess the difficulty I'm having with this, just from a pure legal standpoint, is, well, number one, we've had precedent in the past, with other governors who've done it with both parties. Again, taking the party hat off. Blunt waited, I think former Representative Tom Dipsey, it was 400 days almost before he was put in. Carnahan was a culprit as well. And every single governor probably has, and some people's interpretation could be saying they could have been said to have been, had unreasonable delay. But ultimately, the issue of reasonableness probably needs to be decided by who? I mean, it's probably by the courts. They're charged with the judicial interpretation of that. So how do you grapple with that? I mean, how does this become our job to interpret statute when we're the ones actually charged with changing it if we don't like it?
I believe that we need to draw a line in the sand until the current resident of the mansion and future residents as well, and this goes along to the courts too, that if they do not follow to the best of their judgment in a reasonable way the statutes and the law that are set forth, then they will be held accountable. Whether or not we change the law to add a specified time, that's up to the full body in the Senate. That could be debated.
Should we have impeached Blunt, in 2008 for the 400-day delay?
Yes. If I were in office and I would guarantee you that I would see it in the same way, and I wouldn't tolerate it. I don't think we ought to tolerate it with this administration either. We need to set a tone for those who follow that this is not going to be acceptable practice. And so, to answer your question, I don't know that I can answer it fully. However, I do believe that if we allow this type of behavior to continue, it will continue.
I guess from our perspective of looking at this as our question, I think that we have to grapple with is this an impeachable offense? Is this rise to the level of willful neglect? Because there's so much discretion in current statute that has been exercised in the past because of our, frankly, the legislature's inability to deal with this issue in the past, to have that bright line rule, because without that bright line rule, I don't know that we have the authority, frankly, we have the authority certainly, but I don't think we have the reasonable grounds to say that, this one is willfully neglect of a rule that moves, in time and in the circumstances.
Then I would go back to the chairman's question about whether or not we should add in the numbers for the majority party. And I would say, okay, if that's a factor, then let's add it in, because it does make a difference. And whether right or wrong, we have had over 285,000 Missouri citizens affected by this. They've had no voice in the taxation that's being passed, or the changes in policy. Who do they appeal to? And that's the central question.
I think the central question is they appeal to us to actually do our job and change the statute if necessary. They don't appeal to us to necessarily come forward with the impeachment articles that I don't think has legal merit. That's the issue that I'm having. But I appreciate the inquiries. Thank you.
Other questions from the bill sponsor? Seeing none, Representative Bratton, I would have you come up. Thank you very much.
Mr. Chairman,
something else you want to say?
I have two witnesses.
We're going to have witnesses after we hear from Representative Bratton.
Okay. Thank you, sir.
Hopefully we're going to hear all the witnesses today. Representative Bratton, just proceed, please.
Thank you, Mr. Chairman, members of the committee, Representative Rick Bratton, Cass County, the 55th District. Bringing forth House Resolution 923. These articles have to deal with the scanning, retention, and release of 163,000 people's vital records or source documents that were given away to investigators by what we can tell is we haven't gotten any answers to why the entire list was given away of all these vital records. But first and foremost, our oath of office is to protect our constituents and everything that they hold dear, their privacy. Our oath of office is the Constitution, and to protect that and what it says. And when we have a governor that is going outside the scope of, and I believe his administration, who has gone outside of what their checks and balances are to enforce the laws that are in statute right now, I think we need to hold them to account, and that's exactly what these articles are to do, to initiate that process to investigate these matters. The Article 7, Section 1 states that grounds for impeachment would be against crimes, misconduct, habitual drunkenness, willful neglect of duty, corruption in office, incompetency, and offenses of moral turpitude and oppression in office. And I would say from what we gathered from these past couple of years in these investigations, when we could not receive one single answer as to why people's vital records were being scanned first and foremost, when it was prohibited by state law to begin with, and then to further dive in, that even after the governor comes out and orders stopping this, no one within his departments, not one single person, was held to account for these actions. No one even came forward as to being the person responsible for these actions. And yet we have 163,000 people within this state their documents were squandered and given away. And I think it's our duty as a legislative body to move forward, to hold those to account that have, in my estimation, have broke the law or have neglectfully not held those to account that they are in control of. I was, in the United States Marine Corps, and I was a squad leader, a platoon sergeant, and if I had someone within my squad or within my platoon that was acting out and was not doing what they were ordered to do, it was my duty and it fell upon me to hold those to account. But when we see this has happened to the citizens of our state and through the department of our governor, and to this day has not held anyone within those departments to an account, I find that neglectful and completely a breach of the public trust. And I just think that it's our duty. It's not I look at it as a non-political issue. This is a Missouri issue, and we need to hold those account. I don't care what party. I don't care if it was a Republican governor. I don't care if Democrat governor. We need to hold those account that breach the public trust in the way and the manner that these have. During the investigation in which the chairman chaired the committee, the auditor Tom Schweik, did an investigation, and even stated that through his investigation that they absolutely broke the law, and it was Section 302.183 that they shall not comply with the Real ID standards, the scanning of these documents. And yet we find that they were retaining this. And then we had the governor come out and was adamantly saying that this was ridiculous, this was not going on, this is blatantly false. So not even just a couple weeks later, after they finally disclosed it, yes, this was happening, and these documents were given away to a Social Security investigator. No one was held to account at that point, and still to this day, no one has. So I think it's our duty. He's had plenty of time to investigate within his cabinet, within his departments, to find the the people responsible for these matters. And I think it's time that we act. We've had plenty of time for other viable options to hold him accountable and his department heads accountable. And now I believe it's our time to act. So I know we have plenty of witnesses, and I don't want to set and belabor the point, but I'd be happy to answer any questions.
Let me just ask you a couple of questions. From your resolution, you specifically enumerate willful neglect of duty. And as I understand it, you cite the state law 571.010, which prohibits dissemination, basically shall not be made public of that, the records that are concealed.
Correct.
Is there a penal provision in regard to that you're aware of?
Is a Class A misdemeanor.
Okay, so it is. In fact, it's in your resolution. I read a little further. In fact, could that also constitute misconduct in office if he's violated that statute? Is that also possible?
I believe so. Yeah, and there's also several other. Let me look here at my notes. Yeah, any of the close records must be specific. This has to deal with governmental close records. Section 610.032. That it must be specific to a person or person of interest when you're giving out these closed record documents, as these were, and that also had an penalty provision in it as well.
Sure. Let me ask you a couple questions. You suggested somehow that the governor, now specifically, no one claims the governor having giving out these records himself, doing it as a personal act. Is that correct?
Correct.
I mean, he didn't email somebody, or I'm not sure exactly how they were disseminating more. That story is old in my mind, but even though I was involved in the investigation last August, but at any rate, no one claims he did it himself, right?
Right.
Right. Do you believe the fact that he held none of his, to your knowledge, no one was ever disciplined or punished or even called out in regard to doing something wrong. Is that right?
I believe that not calling anybody out, not calling it for an investigation, not doing it during that investigative process, he was not, him and his cabinet, they were not willing to help in that investigative process. They did everything they could to block and stop and maneuver around that. That to me is a willful neglect of his duty when something as major as this has occurred. And that's
I guess maybe I don't have to remind you. I remember one of the testimony of all, we basically, every one of his legislative people were called into that committee and sworn under oath, right?
they were.
And even though there had been public information about this scandal, this release of this information, without an exception, every one of those people denied they'd ever had a conversation with the governor about it. Is that right?
Well, that's what's crazy about it. I mean, they're with that big of a collaborative effort.
I mean, there was some news coverage at the time, right?
There was.
Yeah, and I mean, it would strike me that it was certainly beneficial to the governor that none of his people ever talked to him about it. Is that correct?
Correct.
Okay. The fact that he did not do anything, hold anyone accountable, is that an aggravating circumstance to justify the action which you propose?
I believe so, because no action is an action. In my estimation, and by all the things that did occur, and not to do anything, I absolutely believe it.
Did he ever say he was sorry?
No, and he's been adamant against even coming out and even talking about it for anything.
Okay. Other questions of the resolution sponsor? Representative May.
Thank you, Mr. Chair.
Proceed.
Thank you. Our chairman sort of touched on this, and again, and I'm going to kind of echo my colleague's statement about, the difference between the legislature's interpretation of the law and at what point our checks and balances fall into place as opposed to a court. And so my first question is fairly technical, but the way that I read your articles, basically, you've got a lot of whereases, which as an attorney, I see those as a list of sort of factual allegations. But your ultimate sort of request at the end of the day says that it looks to me that the basis was the failure to punish. So, I mean, when I look at the final pages of these articles, it just says that they knowingly failed to immediately discipline and knowingly failed to immediately discipline as the basis for the what a court would call the remedy or the relief that you seek, which would be the furtherance of the Articles of Impeachment. So, coming at it from that perspective, I don't see anywhere in the law that requires an executive to take a certain action or not action with the departments.
Well, he's in charge of them. I mean, he is their CEO, and when they're acting out and breaking the numerous laws that they did and the breach of all the public's trust, absolutely, he should be held to account.
And I'm not trying to get into the should or shouldn't. Again, I'm going to look at this as a strictly sort of these are legal arguments. And so when we come down to should or shouldn't, I suspect, and again, to the best we can take the partisan nature out of all of this, it still strikes me as there are a lot of things that members of both sides of the aisle might think that anyone in this building should or should not do.
Well, if you were in a
you're
household
speaking-
and somebody was beating somebody and you willfully just stood there and allowed them to continue to beat and murder somebody, would you not be charged with something for that neglect of?
Actually, I don't believe that there is a law that would allow me to be charged for doing that, and that's part of the basis of our criminal justice system and our laws. And I mean, that to me though it's really conflating the issues because it's an apples and oranges analysis. And again, I'm not trying to speak to should, sir. I mean, I'm not trying to speak to should or shouldn't. I guess what I'm trying to say is, we have a set of laws, we have a set of rules, and the way that I read these articles is it says that okay, we should take this action or this remedy, this relief should be granted based upon the lack of punishment, when there's nothing in law that says the executive shall or shall not punish those in that situation. And what we end up doing then is substituting the legislator's will for a court's will as to whether or not that in and of itself is a basis for the relief that you seek. So then the other thing is that, you know, my understanding is that you spoke a little bit about investigations, and my understanding is that we have had, and you may have been a member of that committee as well, that we did have an interim committee that did some investigation, and that report, if I recall, doesn't seek the remedy that you seek. The auditor has investigated and also hasn't sought the remedy that you seek. So that's kind of where I...
Because the powers lie within us for the impeachment process. You know, that they don't have that power to do anything like that. The recommendation of the committee was the laws that needed to be changed, and the laws that were changed with, what was it, I think, Senate Bill or House Bill 252.
Right, and I actually, I mean, I thoroughly support that. In other words, I think that that's, again, when we're talking about the separation of powers and what our job and our role is supposed to be, I think that investigating and looking into a problem and saying, okay, we need to tighten our laws, just as my colleague was speaking about with the last witness, in that, you know, the way that the election stuff works is that there's some discretion there, and maybe the responsibility to some extent has to lie with us for not having, you know, in that specific instance, not having it laid out. And so to the extent that the legislature sees that there's an issue, I think that it's incumbent upon us to not address the laws, as opposed to this, what I would consider to be a very, very drastic relief, when there, in my opinion, are inconsistencies in statutes.
Well, I don't think with the numerous statutes with this case, when it was investigated, that were broken, that dealt with basically the same thing, and the fact that it's his charge as a governor to carry out the laws that are distributed. That's his duty, and the fact that the people he's in charge of weren't carrying out the laws, and they were going above and beyond what the law and breaking the law totally against what it was saying.
And that's exactly my point, sir.
That's our duty as a checks and balances. When that governmental entity separate of ours starts and going above and beyond and making their own laws, we hold them to account, and that's what the Articles of Impeachment are, and that's why I brought them.
And that's exactly my point, though, is that we reasonable people can disagree about the interpretation of that law, which is why that job is in the paradigm of our court system, and where I think that it absolutely should be. And again, with respect to your specific allegations, in fact, there has been a court that's already held an evidentiary hearing and found against the plaintiffs, basically found for the defendants. And we have had an auditor do an investigation and made some recommendations.
I think the lawsuit you speak of has to do with other allegations, not the allegations in regard to they have to do with the elections. Is that what you're talking about?
Yeah, there's been a lawsuit that was filed about concealed carry endorsements in the DOI in Stoddard County. And Judge Meyer found in favor.
Ordered the cease and desist of the scanning of the source documents within that county.
Right.
But found that no dissemination of records had occurred.
No, it had occurred. Within this committee, they found out 163,000 had them.
Within this committee versus the Stoddard County case, I think we're talking about two separate.
I'm just saying that was the case that preempted the investigation and investigative committee to where we found out it was not just Stoddard County, it was the entire state of Missouri. And this huge compliance with Real ID and how they blatantly went against the state statute of complying with Real ID, sending thank you letters to our governor for complying with Real ID when it was strictly prohibited by state statute of the adoption of Real ID, and the Department of Revenue director sending how well they're coming along with the adoption of that, you know, and nobody's been held to account.
And I mean, I appreciate your recitation of those facts, but I still think that my understanding, I mean, I have an order in front of me from March of 2013 that basically says an evidentiary hearing was adduced and that that a preliminary injunction was denied. So a court has looked at it and had an evidentiary hearing. As is the auditor looked at it, and I can read from the auditor's report.
Right here,
It
it says that they did break the state law.
That the DOR's actions in scanning did not technically violate state law. That there's a conflict between failure to promulgate a rule or failure to do something else. And again, I come back to my issue is that we've had other people to look at it that have come to different conclusions, and so that's sort of my point, is that I just feel that this body's job plays a different part in the process. And as we heard from the earlier witness, quoting the Supreme Court justice saying that all impeachments are inherently political, and that there's where my concern lies. And I think that what we come down to is just a different interpretation of exactly what the law is. And for my money, with respect to this particular resolution, more importantly, what the failure of a law to direct the executive to punish or not punish under certain circumstances, it doesn't exist. And so I think that it's incumbent upon us to address that issue if the legislative body feels that that's the proper policy, and take that route, because that's our charge, as opposed to seeking the relief that you seek. And, with all due respect, again, we can agree to disagree, but that's sort of my point. So thank you very much for sharing. Thank you, sir.
First, Representative Cornell. Yes.
I guess you said it a couple times now, so I just wanted to kind of clarify on, you said that, nobody's really been held accountable, but didn't the director pretty much be forced to resign because of all of this?
Well, upon the release, he resigned, but I mean, he had just been in the director spot for such a short amount of time versus the time span of when this was all occurring.
Somebody has been held accountable.
But if you look at the report, if you look at the news release of the governor thanking him, saying job well done and best wishes for your future endeavors, that's not holding anybody to account for what they did.
So just hasn't gone far enough, I guess, is what you're really saying.
Well, that's somebody just resigning and telling them great job. That's not saying, hey, this guy was a bad actor and he's fired. That's different than saying, great job, just glad you're resigning, blah, 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 hope you're the best. That's not holding anybody to account.
Thank you.
Representative Kelly.
Name clear? Yes. Thank you, Mr. Chairman. You seek the impeachment of Jeremiah Nixon.
I do.
What law did Jeremiah Nixon break?
Well, it's the fact that he's the head of the executive branch.
I understand.
And we, the legislature.
Can you tell me point to some law that he broke?
No, but I'm not charging him with a law. Well, I'm not charging him with this crime.
My questions are, who did break a law?
That's the thing. Nobody's come forward, and with all the investigations and all the types of political games being played, nobody has. But the fact is that it did occur. They just can't point the finger at anybody.
The governor didn't break the law.
His branch did.
You don't, but somebody else did, but you don't know exactly who did.
But within the investigative committee, that was the thing. They knew they had all the evidence, but they could never point the finger.
I'm not finding fault with your answers. I'm just trying to get factual answers.
Right.
You cannot point to a particular individual who you assert broke a law.
Correct.
Okay. What law was broken?
We have section 32.091. Department of Revenue shall not collect info on personal identification, their source documents, things of that nature. 163,000 people's source documents have been scanned and retained. Section 302.183, Department of Revenue shall not amend procedures to comply with the Real ID Act.
Tell me how specifically when the first of those was broken. Give me any example. See what I'm troubled here by.
Well, with the adoption
let me finish my point. What I'm troubled by is the shackles of having been in court, specifics are really important. And I know that you talked to 163,000 records, but can you give me a single example where a particular law was broken?
Well, that's 163.
But no, I know, but if 163 were, the law was broken 163,000 times, there should therefore be at least one example of a given law being broken once.
I guess explain what you're talking
I
about.
want to know where, I want any example of where a law was actually broken. A given on some
Whenever
day.
they, well, that's the thing with the Stoddard County. That was what brought that. Was that one individual realized they were scanning his
The
document.
court found that there wasn't any violation of law, didn't they?
Well, they put a stop on that, but with the investigation, they found that they had been. And
Is it fair to say that you can't give me?
I can't give you exact dates, but with the investigation and to go further with what Representative Mitten had said with Auditor Tom Schweik, to take it further, that let's see, either way, this is what he said with the adoption of rulemaking and things. Either way, the violation of state law did occur. So, I mean, it did occur within his investigation. He found that it did occur.
Schweik did.
Schweik did. It's right here, and I can get you a copy of that. That it did. Now, it didn't list out
He
the.
doesn't point to, okay.
He doesn't point to.
I'm done, Mr. Chairman. Thank you very much.
Okay, thank you. Oh, other questions? Representative?
Which one?
You.
Representative Bratton, let me ask you questions regarding two different topics. One was brought up by Representative Mitten, and that has to do with a chief executive's responsibility for those under his control. Let me ask you this question. You are experienced in the military, are you not? When a private or when an airman or some type of an enlisted person commits either a war crime or some type of malfeasance, if a superior, a lieutenant, a captain, a colonel knows about that malfeasance, that bad act, and does nothing about it, what happens to that superior?
He gets charged. Absolutely.
So it's not acceptable for a superior to know about a wrongdoing and to do nothing.
Correct.
Same thing with a corporation. If a CEO, a member of the board of directors, knows about criminal conduct, let's say accounting misconduct of employees in that corporation, knows about it and does nothing, who can be charged under the law?
Well, the CEO can.
Correct.
And to take that a step further, I mean, and if he didn't, well, then that shows a complete incompetence on his part that he has no control, has no clue what's happening within his departments and his cabinet.
The fact of the matter is, if and this is a ridiculous example, but it's a true example, if the governor knew that his staff was charging admission price to his office and did nothing about it, would we hold the governor accountable, even though he wasn't the one doing it? Of course we would. So to suggest that because the governor himself wasn't the one violating the law, I find patently ridiculous. If you have an employee out committing negligence in a vehicle, what does law allow when you go to file a lawsuit on behalf of the harmed party? File it under the theory of respondeat superior. You file it against the employer. So the fact is you always hold someone in charge responsible when they fail to take acts to make things right. The second thing I wanted to ask you about is this question of a specific act of criminal conduct when it comes to your articles of impeachment. It was asked, can you name a specific, one specific time that a criminal act was committed? And I think your response is, well, we had 163,000 approximate criminal acts committed in aggregate, and it was against, in violation of the 571 chapter, which prohibits release of personal identifiable information regarding those Missouri citizens that own or hold a concealed carry permit. Is that correct?
Correct.
Well, I mean, you may not want to answer. I can tell you that I hold a concealed carry permit. You hold a concealed carry permit. Fact is, we have two examples sitting in this room of people whose personal identifiable information was given to federal authorities in direct violation of Missouri law. Isn't that correct?
That's correct.
So right there for the representative from Boone County, there are two examples of direct violations of Missouri statute. And it was done by a member of the executive. I think if the representatives on this committee took a look through the records from the Privacy Protection Committee, investigative committee from this summer, and looked at those documents, you would be able to find, I think, at least two, if not three members of the executive branch, specific named employees that were responsible for the release of that information in the Department of Revenue and members in the Department of Public Safety.
Yeah, I think it was a couple
Which-
times they downloaded the entire deal on a disk and handed it over. So, I mean, there was somebody, it's just they haven't been disclosed.
Thank you.
Other questions? Representative Clark.
Thank you, Tim Clark. Gentlemen, I know you're not a lawyer, but I'm gonna throw some terms out there because it appears as if you've done your homework just a little bit, but you're familiar with what a subpoena is, correct? Correct. And if you get a subpoena and you don't do what the subpoena asks you to do, what happens?
You're held in contempt.
And then when you're held in contempt, what happens to you?
Well, it's up to the judge's discretion of what he wants to do.
But you go to jail. That's one of the remedies. And you grasp the concept that when the federal government issues a subpoena and you don't comply with the subpoena, they don't take that very lightly.
But the actual language within the statute, it had to be specific, and that's what the subpoena, they have to be specific to a person or persons, not an entire aggregated list of documents.
Now, what you're doing is issuing a legal analysis. We've already established that this isn't a court of law. And would you agree that it doesn't really matter if the governor broke a law or not? You're not saying the reason why we should impeach him is because he broke a law. It's because of the totality of his circumstances on how he handled this real ID information transfer, correct?
I think it has to do with all of the above. I mean, the fact that he had all this going on, the fact that he didn't hold anyone to account, and yeah.
Well, now let's back up a little bit. If the governor didn't break a law, whether Missouri or federal law, regarding this real ID transfer of information, do you think he should still be impeached under your articles of impeachment?
I think with what went on within his departments, yes. And that no one...
So then let's take the issue of did he break a law or not and set it aside. So now all we're doing is looking at the governor's behavior with, say, the Department of Revenue and transfer of information. So now what you're asking us to do is impeach a governor because you disagree with his ability to either supervise or not supervise a department?
Well, not just supervising a department. I mean, it has to do with people's most intimate documents being squandered away.
But gentlemen,
and gone.
Again, take the issue of breaking a law and set it aside because you said that doesn't matter. Our entire conversation...
No, it does matter. It's all part of it.
I don't want to bring you back to the top of your circle because I know it's confusing. So let's just forget about breaking the law. The only issue left is what the department did and whether or not that's an impeachable offense. Do you think it's appropriate to take a look at the military and examine the responsibilities imposed upon officers, NCOs or the brass? Take that and put the same type of responsibility in a political arena?
Well, if they had that type of setup, then that would be totally within the powers to be. That's how our Constitution's set up, is to where they're held into checks and balances. And when they start with the overreach of their power, that's when we, as a legislature, have to hold them to account.
So
regardless of political affiliation.
So then in your articles of impeachment, is the overreach of power complying with a federal subpoena?
Well, no, No, it has to do with his incompetency to,
In that case,
I
gentlemen,
guess, manage.
In that case, gentlemen, in case I'm missing something, and maybe the committee can point it out, you've just helped me come to the realization that your articles of impeachment are baseless. You've already acknowledged that.
Well, you're
it doesn't
trying to
matter if we break the
remove
law.
a section of the most important part where it's breaking the law. See, you tried to
But
dissect
you
that.
already told me it doesn't matter.
No,
if
it does
we
matter.
are or
I
not.
told you it does matter.
Okay, well then, not that the auditor is an attorney, but that's not a big deal. But where in his recommendations does it say that we need to impeach him?
In his recommendation, well, he doesn't have that authority, so he's not going to recommend that.
But he has the authority to say whether or not the governor
That he
broke
broke
the
the
law.
law. He saw
Is that
that. Yeah.
because of his accounting degree?
It's because of what he saw was so blatantly true. I mean, anybody could see it.
Thank you. I'm glad that you think it's so blatantly true. Obviously, we don't have a disagreement.
All you got to do is
Otherwise,
read the
we wouldn't be here.
statute, gentlemen. Read the
Otherwise,
statute and see the facts. That's what
Gentlemen, I'm trying to get you outside your bubble. Because I know when we get in this building, we get into a bubble. And we forget about the real world. And I know you don't want to acknowledge the federal government. I know you don't want to even acknowledge their subpoenas. But thank God our governor does.
Well, what subpoena was issued to? That's the thing. To get 163,000 people's source documents?
Mr. Chairman, I want to thank you for indulging me with this
Thank
kind
you.
of question.
Any other questions? Seeing none, thank you. We're going to go directly. First of all, I want to ask those who would like to testify in favor of any of these resolutions, please raise your hand. Those who would like to testify against, please raise your hand. And for informational purposes, please raise your hand. Thank you very much. We're just going to start for testimony in favor of the resolutions. Please come forward and state your name, spell it for the court reporter, and we need to keep the discussion under 2 or 3 minutes so that we can maybe complete this.
I will keep it very brief, Mr. Chairman. For the record, my name is Ron Calzone, C-A-L-Z-O-N-E. And before I begin my testimony, my brief testimony, I would like to make a presentation to the committee. We have about 760 witness forms, people who are interested in this matter. There were 5 of those 760 or so that are opposed to these articles of impeachment. There are about 3 who are for informational purposes. The balance are in favor of the articles of impeachment.
We'll just leave them there and we will receive them. Thank you.
Okay, very good. I really hesitate to ask the committee this, but I think that you need to think a little bit less like lawyers in this matter. This is a political process. It is not a legal process. It is not a process for the court. I want to exemplify that by reiterating a couple of quotes.
Define what political process
I'm
is, so
about to
people
do
don't
that.
understand.
That's
Okay.
exactly where I'm going. Both Representative Marshall and Representative Moon quoted Article 1, Section 1. And if you remember that phrase that they quoted started with the word that. Now, my 6th grade English teacher taught me never to begin a sentence with the word that. And in fact, the Constitution is grammatically correct because what they left out was a preamble to Article 1, Section 1. Now, as I read the preamble, I want you to envision 8 million Missourians sitting in a chorus reciting these words, because these are the words of the people of Missouri. They said, in order to assert our rights, acknowledge our duties, and proclaim the principles upon which our government is founded, we declare, the people of Missouri are declaring. And then you have each of the articles beginning with the word that. And so the people of Missouri are declaring that all political power is vested in and derived from the people, that all government of right originates from the people, is founded upon their will only, and is instituted solely for the good of the whole. That's the political that is involved in this process. It's not partisan politics, but it is a political process in the sense that the people of Missouri, those 8 million people who made this declaration, are saying all political power is vested in us. We are loaning it to the governor. We are loaning it to our representatives. We are loaning it to our senators. It's on loan. You are stewards. The governor is a steward of that political power. And when someone fails in their stewardship, they should be held accountable. So the impeachment process is about guarding the people's political power. It's about guarding the people's political power as they reserved it in Article 1, Section 1 of the Constitution. It's not a criminal process, and that's evidenced by the list of things for which you can be impeached. One thing says you can be impeached for committing a crime, but it goes on to say in the Constitution that you can't be held criminally liable. That's a separate process. All of the other things listed under the list of things that a government official can be impeached for are non-criminal in nature. And so you should not use the same standard of review that you would use in a criminal case to determine whether or not the governor should be impeached. In fact, the question before you in this panel is not whether or not the governor should be impeached, it's whether or not you should take it on to the full body for them to decide whether or not the governor should be impeached. And so I think that maybe we're thinking a little bit too much like lawyers in this committee. I would like to very briefly answer a question or two that was posed last week. Representative Kelly, you asked, shouldn't it be left to the court? And I would suggest to you that because of what I just said, no, it should not be left to the court. But I also would add that unfortunately, because of a terrible mistake we made in 1945, it will be left to the court anyway. Because if the House of Representatives decides that the impeachment is required, then the Senate is going to pick 7 eminent jurists. And so there will be members of the legal profession, members of the court that are deciding this matter, even though I think that was a terrible mistake we made. And then Representative Colonna, you asked about these 3 HRs. You said, do any of them in themselves, yes, this last week, do any of them themselves constitute rising level of impeachment? And I would say, you know, my own personal opinion, probably not. Because I think the reason that you impeach a governor or anyone else is not because they made one mistake, but because of a pattern of behavior. Has the governor established a pattern of behavior that is an affront to the people's political power? So the real question before this committee is, has Governor Nixon operated in a fashion that exceeds the political power the people have entrusted him with? Is he trampling on the political power that people have reserved for themselves? Blackstone wrote about impeachment. He said that impeachment is not about crimes, but it's about malfeasance in office. You impeach someone under the common law of England because of malfeasance in office. So please think a little bit less like you're in a court of law.
Any questions of the witness? Seeing none, thank you very much for your testimony. Next witness. We do encourage all the witnesses to fill out an information form. Please take the test. So go ahead.
Thank you for allowing me to appear and testify. My name is Pamela K. Grow, G-R-O-W. I'm the chair of the 120th Legislative District Republican Committee. My state representative, Jason Smith, resigned on June 5th, 2013, the day after he won the special election in Missouri's vacant 8th Congressional District. This created the vacancy in the 120th, and this vacancy meant that my neighbors and I had no representation in the legislative chamber closest to us. And that situation persists to this day, more than 10 months later. The veto override session of last year has come and gone. We had no representative. The special session of last year has come and gone. We had no representative. Tax day has come and gone. We had no representative. The regular legislative session during which laws are passed that we will have to live under and obey is rapidly coming to an end, and we have no representative. The people who are being governed must give their consent as legislation is considered, which will add to or subtract from the laws of our state. I think of my elected representative not only as my ombudsman with respect to constituent issues, but critically as my advocate during legislative deliberations. Late spring is particularly important. I'd like to point out that for the 2013 session, 98% of the legislation that was truly agreed to and finally passed reached that benchmark after the second week in April. In the second half of 2013, despite the vacancy in my district, I was still intensely interested in and vested in what happened in the legislature. My county, Phelps, has parts of 4 representative districts. I did contact the other 3 representatives during September's veto override session, but I realized that they were not really in any way bound to represent me. I was not their constituent, and their priority was representation of people in their district, and this was as it should have been. but roughly 30,000 people in my district were disenfranchised. In late October, the officers of the Republican committee in our district composed a letter to Governor Nixon asking him to call a special election for the April municipal election date this year. We knew that the state's constitution stated in Article 3, Section 14, that it was the governor's duty to call a special election for any vacancy in either house of the legislature, and state law further stipulated that this election should be called without delay. Use of the April election date might be less disruptive to the election authorities who would already be anticipating an election, and we also knew that the April date might afford us a representative able to participate in many of the important votes. We'd have someone accountable to us as laws governing us were being made. I hand-delivered this letter to Governor Nixon's office on November 7th of 2013, and I received a response 1 week later. I would describe the reply as a form letter. By early December, the legislature was in special session and the 120th district was completing 6 months of disenfranchisement. Another House district, the 67th, lost representation, and then the governor himself, as you've heard, created a third vacancy in the 151st district. Two of these, about that time, the governor also created a Senate vacancy in the 22nd district. 2 of these 4 districts had been represented by Republicans, but 2 had been represented by Democrats. Some of us in the 120th felt that the system of checks and balances in our state government might provide us redress. We found an attorney who was willing to represent us in filing a petition for a writ of mandamus. We wanted the court to instruct the governor to do his duty and call special elections for the 1 Senate and 3 House districts. This case was filed in Jefferson City's jurisdiction, the Cole County Circuit Court, on January 2nd, 2014. 11 plaintiffs, at least 2 from each of the 4 vacant districts, brought this petition. I was named the lead plaintiff. The governor was personally served on January 13th of 2014. The first case review was scheduled for January 27th in Cole County Circuit Courthouse with Judge Daniel Green. All 4 plaintiffs from the 120th district attended, but the counsel for the governor did not appear, and we were dismissed. I believe that the governor's counsel was personally summoned later that day to the judge's chambers. On Friday of that week, January 31st, Governor Nixon scheduled special elections for the 3 vacant House districts for August 5th, 2014, which leaves the citizens of my district with no representation for 14 months, including the entire legislative session for this year. When the decision from the Cole County Circuit Court came on Tuesday, February 18th, that the petition was denied, our case was filed in the Missouri Western Court of Appeals on February 19th. A terse, 1-line denial of our petition issued forth the next day, February 20th. The case was filed with the Missouri Supreme Court the next day, Friday, February 21st, and a 1-line denial was issued on February 24th. This sequence of events shows you that the state judiciary is not functioning as a check on the power of our executive, who by his actions has caused my district to suffer a 14-month-long vacancy. Because of his delay, the 3 House districts have no representation whatsoever for the current legislative session. This is approximately 100,000 people. The vacant Senate district's 140,000 people will not have representation until inauguration on January 2015, more than a year after their vacancy was created by the governor himself. So 250,000 people, give or take, lack their full complement of representation in the state's legislature because of the governor's delay. The judiciary has declined to check our governor's power, which he has used to disenfranchise the people with a delay of more than an entire legislative session. Delay in scheduling an election is an infringement on the right of suffrage. State law deals harshly with infringements on the exercise of the right of suffrage, deeming some of them to be felonies. Those would be Class 1 and 2 election offenses. Since some of its bills this year deal with elections and voting, the Missouri General Assembly must be concerned with the right of suffrage, and I would urge the legislature to act where the judiciary would not and check the power of the governor to infringe on the people's right of suffrage by unconscionable delays in calling elections.
Any questions of the witness? Representative Cloner, briefly.
Yes, sure. You have answered some of my questions, but I did want to get a couple quick things. Hey, you've been a committee woman for how long?
5 years.
5 years, okay. 2007 looks like Governor Blunt left about 13 months of a vacant district in St. Charles. Did you ask for his impeachment? No, I didn't think so. 2008, another 10 months with Governor Blunt, St. Louis County. You asked for Governor Blunt's impeachment?
No.
Okay. I gathered from your testimony you're not happy with the courts, but you know you can impeach them too. Have you gone forward with impeachment proceedings against them?
Let's move on. I mean, she's not, that's not the purpose of this proceeding. So, any other questions of the witness? Thank you very much for your testimony. Next witness in favor.
Good afternoon, members of the committee. My name is Dave Rowland. I'm an attorney and a constitutional expert. Several of you have heard me testify on various other matters in the past few years. I actually filed the case on behalf of the disenfranchised citizens.
Was the ruling based upon mootness? Is that what?
There was no ruling. A petition for a writ of mandamus is discretionary.
They decided
The court can
that
decide
it was not
whether they
within their discretion to act. They decided not to exercise.
They chose not to.
I think.
So there was no ruling on the merits.
Mhm.
The courts never said who was right, who was wrong. They said, we're not going to deal with this.
No, that's not uncommon for a court to not be involved in a, quote, political issue, right?
That is correct.
And when I say political, I'm talking about political in the sense of the power of people to exercise power and so forth.
Well, and one of the arguments that the Solicitor General put forward in the case was that the courts were in fact powerless to hold the governor's office accountable in this regard.
I'm sorry, I didn't mean to interrupt you.
So I wanted to make a handful of points. I've provided written testimony that I hope each of you will consider that more fully fleshes out my perspectives on this. But I specifically wanted to address a handful of issues, one that was brought up by Representative McManus, and that is he was focused very intently on this idea of, well, who's to say when delay takes place and when it doesn't? Under these circumstances, we don't even need to get to that question, because what the governor argued through the Solicitor General is that he, in fact, doesn't have any obligation whatsoever to call elections when there's a vacancy. That's the official position of the governor's office. Now, we've got a constitutional provision that, ever since this state was founded, has given the governor the exclusive power to call for elections to fill vacancies in the legislature. There's no other way that people who have lost their representative can get a representative than for the governor to take this action. And the governor is now arguing he has no obligation whatsoever. That's a direct conflict with the specific wording of the Missouri Constitution. So I don't even think we need to get to this question of, well, is a year and a half too long to wait to have a representative in one house or the other of the legislature? We have a governor who is directly defying the Constitution's text that says he shall call for elections to fill vacancies. So in addition to just the baldness of the governor's refusal to abide by his constitutional duty, I think that it's also imperative to think about the citizens who are being disenfranchised. We've heard numbers along the lines of about 250,000 Missourians. It's more than that now, because Senator Root was appointed to a state commission. His district is no longer represented in the Senate. We've had Representative Ellinger die while in office. His district is no longer represented in the House, and I haven't heard any indication from the governor's office that he intends to call elections to fill those vacancies either. So now we're up to well more than 1/3 Missouri citizens who don't have a voice in the people's house, in the legislature, which is supposed to be their most direct avenue to controlling the government that rules over them, that creates the rules that they are forced to live by. And so many of you know, when I come and testify at the legislature, I almost always do so for informational purposes. I do that because I think it's important to maintain a certain level of detachment from politics. And I do try very hard to be fair when I deal with issues and present information to the best of my ability. In this circumstance, I believe that what Governor Nixon has done in willfully choosing not to allow citizens to elect representatives for themselves for the legislature, I think it is an egregious violation of his personal duty, also an egregious violation of the constitutional rights of those hundreds of thousands of Missourians who now have no voice in their legislature. And that's why I think that the House of Representatives has clearly the authority to impeach him. Whether it chooses to do so or not is ultimately in your hands. But I think there's no question that you've got the grounds for doing so. And if I was sitting in your seat, I would vote to impeach for his refusal to abide by his constitutional duty.
Any questions? Any questions of the witness? Thank you for your testimony. We appreciate it. Other witnesses in favor?
Mr. Chairman, and may it please the committee, my name is Major Eric Vaught. That's Eric with a C. V is in Victor, O-U-G-H-T is in Tango. And I am the commander of the Lawrence County Sheriff's Auxiliary. I'm here presenting officially with the approval of my superior, the Lawrence County Sheriff. I should also note that my wife has submitted written testimony in favor of all three of these resolutions, and I would be ill-advised to not support that testimony. But I will restrict my official comments to H.R. 923, since that is what is that is directly affected our organization and is why I'm here officially. I see an opportunity here to kind of put a face on some of the people that have been affected by that issue. The Lawrence County Sheriff's Auxiliary is a uniformed civil service that operates under the sheriff in Lawrence County. We do disaster response. We provide some routine services for local law enforcement, including communication support, intelligence, chaplains, various other services of that nature. Among our requirements to volunteer is the Missouri CCW. All of our volunteers are required to have one and to maintain in good standing, along with other training and other qualifications. So essentially, every one of our volunteers has been directly affected by this. I did obtain my Missouri CCW within the period of the alleged disclosure.
So your records were communicated to the federal government, to your best knowledge?
That is my understanding.
Okay, go ahead.
It is also beyond the possible violation of records of myself, our volunteers. We are also, I am personally aware of volunteers and non-volunteers in the community who either had their records scanned or were refused a renewal or application for a CCW on the basis of refusing to have their records scanned. I'm also personally aware that of individuals in our county who went through that process, who then requested assistance from the sheriff, who then went to the Department of Revenue, went back to the Department of Revenue, and still encountered the same situation, including after the governor's announcement that the practice would be stopped. So there is the issue of information that was probably violated and distributed to the best of our knowledge. There's also, of course, the issue of disruption to our operations, as we were required then to maintain current volunteers' paperwork in a situation where we were not certain what the law was, how to renew these CCWs, how to actually meet our requirements, the disruption to the operations of the Sheriff's Office as a whole, which is actually still ongoing, since it's just only been a matter of weeks since the new equipment for the new CCW process has been put into operation. And all of that is part of the reason that I'm here officially, and all of that is true. One of the reasons that is compelling to me personally to be here, to have traveled 3 hours twice now in order to submit this testimony, is that this particular occurrence in Missouri happened in the wake of a release of permit information in Connecticut earlier in the year. In that case, permit data was published in a local newspaper along with addresses of permit holders and so forth. When that occurred, many people asked the question in Missouri of whether that could occur in Missouri. Various levels of government in Missouri assured the citizens that it in fact could not, because the law, and in fact they cited RISMO 571.101, required that Missouri citizens' data be held confidential and protected, and it required penalties for violation of that. And in fact, the sheriff's office made statements to that effect, and I myself made statements to that effect at public meetings and in a talk we gave to the community on the CCW process. So to me, it becomes a matter of personal integrity that, based on my correct understanding of the law, that this could not occur in Missouri, and my assurances to people that they should participate in the process and do what was necessary of them to become legal in that process to obtain a CCW and so forth, that it is a question of my integrity that I made that assurance, and that gives me a duty to pursue the process to make sure that it is in fact the case, that we do have an appropriately enforced process in Missouri to protect that data. I should also note that it's not necessarily within the scope of that duty or my official function to care what the end result of that process eminent jurist who may be appointed will be. It is my function to advocate that a process occur, that in full investigation and appropriate resolution of the matter happen, because I don't believe that we can have trust in the integrity of our process and our system unless that occurs and unless it is fully dealt with.
Let me end that with that. We appreciate your testimony. We are required by our rules to not be in session or in session here when they're in session upstairs. And the hearing session is scheduled to begin at 2 o'clock. So I've got to make a decision in the next 3 minutes what we're going to do. But
I am fine, Mr. Chairman, with ending my testimony there if that is
in any questions of this witness? Seeing none, thank you very much. The additional people who have not testified, please raise your hand. I think we have an opportunity. We're going to have to submit the rest of it because I really want to complete the hearing today. One additional witness. I don't know how you choose. Just come up. Whoever's the largest or the quickest or something. Just somebody come forward. Or the smallest if you have compassion. So.
I'm in favor of giving preference to
oldest. That's right. Proceed on. Proceed.
Well, I just ended up being a little quicker than my wife, so I hope I'm okay when we get home. My name is Steve Hausladen, and I'm from the 120th, and I think somebody mentioned getting into the real world, and I think that's where we need to be. I read a poll recently that 20% of the people in the United States believe the United States government does the right thing most of the time. The converse of that is obviously 80% believe the United States government doesn't do the right thing most of the time. And when I go an entire year without representation, and I hear people saying that that doesn't really bother me, it's not really something we take the governor to task for. And I'm not only by myself, but there are hundreds of thousands of people in my same situation. I think you have a big credibility problem when you're telling me that you don't care that we've been without representation for over a year. That does not enter into your mind as something that's an impeachable offense. It's something that's worth investigating, which is what an impeachment is. And I don't know, I guess I'll just...
Any questions of this witness? Spell your last name, please.
My last name is Hausladen.
Representative Kelly, did you have a quick question? Okay. Okay, thank you very much for your testimony, and I apologize for those who did not. I would encourage all of you to submit either today or within the next 24 hours. You can do it over the internet, to my website, to the House email, any written testimony. Subject to that, this will conclude the public hearing to House Resolution 380, 476, and 923. Conclude the hearing today. Thank you. Appreciate it.
You know, we had a water was great.